you for joining us today for the ABA Civil Rights and Social Justice Chair Chat. My name is Adele Rapport. I am the co-chair of the Public Education Committee of CSRJ, and I'm thrilled to welcome you to this conversation. These chats are a unique opportunity to engage directly with the key issues at the heart of our work in civil rights and social justice. Explore the perspective of our expert panelists and spark discussions that inspire action. So today's topic is the state of education, and that is more critical than ever. As we confront the state of education, it's essential to examine how these issues interact with the principles of justice and equity that guide the work of the ABA. We are honored to have Jay Blitzman, who is a retired Massachusetts juvenile court justice and former executive director of the Massachusetts Advocates for Children, a law school instructor, and a youth justice consultant. Judge Blitzman teaches at Harvard, Northeastern, Boston College, and New England Boston College Law Schools, and is a faculty member of the Center for Law, Brain and Behavior, CLBB, Massachusetts General Hospital, Harvard Medical School. Jay is a volunteer with Lawyers Defending American Democracy. Without further ado, let's dive in. Please join me in welcoming Jay to kick off our conversation.
Thank you, Adele. It's very exciting to participate in this conversation, and the focus of our conversation will be, as you indicated, the status or the state of public education. So, my concern is that public education, as we know it, quite candidly, is under attack. Project 2025 has an entire chapter devoted to the dismantling, abolishing the Department of Education. And that is being done through a multifaceted approach, which includes threatening school districts which teach DEI with the withholding of federal funds for public education, threatening teachers who discuss DEI or Black history with prosecution under the Civil Rights Act of 1964, and alleging that they're violating in some curious way the 14th Equal Protection Clause. And the rationale for this approach is to return public education where it belongs, to local communities and parental control. Critics of this approach have questioned whether or not this really is an invitation to return public education to the era of Jim Crow, as part of the whitewashing of history. So, for example, to augment this policy or this goal of dismantling a cabinet level position, an advisory letter was sent to all K-12 school districts indicating that if you discuss Black history, somehow you're violating the 14th Amendment. And this also raises issues of whether or not, under the guise of protecting white students from so-called reverse discrimination, we are really avoiding the reality of what happened with the enactment of the 13th, 14th, and 15th Amendments after the Civil War. When I went to school, these amendments were called the Reconstruction Amendments or the Civil War Amendments. Now, under the rationale is exemplified by the Supreme Court case involving Harvard Law School regarding affirmative action efforts regarding school admissions. An expansion of this thinking is being extended to public education regarding children, and the net effect might well be to chill freedom of speech in schools. Teachers don't know what they could talk about, for example. So in talking about abolishing DEI, diversity, equity, and inclusion initiatives, and talking about not discussing Black history, are we going down a path which will make it difficult for students and teachers to even know what they could say? So, for example, when the advisory letter was issued to K-12 educators, Linda McMahon was asked by reporters, well, can teachers still talk about Martin Luther King? And according to the media reports, Secretary McMahon said, of course they can talk about Martin Luther King. Follow-up questions included, well, what about Ruby Bridges? The secretary hesitated, essentially saying to reporters, well, I've got to get back to you on that. So how do teachers know how to negotiate this landscape? Can they talk about Ruby Bridges? What about the 1921 Tulsa massacre? When the Black community was the middle-class Black community in Tulsa in 1921 was essentially destroyed, wiped out. So this is part, I think, of a concerning landscape, which includes erasing history. Black history, quite candidly, doesn't exist. Black history is part of American history. And pretending that these things have not occurred, I think, is dubious. Removing, and this is part of the larger issues related to the subject matter, which include removing mentions of historical Black figures in the Smithsonian, uh, airbrushing or removing names of famous Americans, not Black Americans, not white Americans, Americans from Pentagon scrolls or rolls, questioning the role of the Tuskegee Airmen. One of the amusing, not so amusing, manifestations of this includes something I think we discussed yesterday, Adele, in preparing for this conversation, and that is the reference of Enola Gay. There was some concern that Enola Gay was would promote gay culture in some way, and this was also concerning to the administration. Well, as we know, Enola Gay was the name of the plane that dropped the atomic bomb. It was not some celebration of gay culture. Perhaps that we should change the name of the Enola Gay to the Enola Strait. I don't really understand that. But when we step back and we look about what this means for public education, are we really talking about returning local education or education to parents and school communities, or are we really talking about imploding the public education as we know it, eliminating it altogether and replacing it with a patchwork of private voucher schools, deregulated magnet and charter chains? This seems to me is the opposite of standing up for equal opportunity and would set the nation back at a time when I believe the overwhelming majority of Americans want us to continue to see it move forward. So this is really, really concerning. And as I said at the outset, this attack on public education is multi-pronged, uh, threatening the withholding of all federal funding to public education, the advisory letters that I've mentioned, threatening prosecution under the Civil Rights Act, and somehow interpreting the 14th Amendment as designed primarily to protect white children as opposed to all children, and ignoring the country's history of slavery. Um, it also includes, and this is an issue that I know that is near and dear to your heart, Adele, uh, unfortunately, closing offices, civil rights offices, or threatening to move them to the aegis of the Department of Justice. So this creates what's known to us lawyers as a right without a remedy. A parent who is aggrieved of an education plan for their student, uh, if you don't have a local OCR office, I know the OCR office, for example, was closed in Chicago, it's closed in Boston, where does the parent go? And there's current litigation regarding that. The reality of having a right without a remedy, which we learned, I think, back in law school. What was it, Marbury versus Madison? You can't have a right without a remedy. But that's the current reality for many American parents. So there's litigation, as I indicated, regarding this in Boston. And interestingly, there's a case now in front of the same federal district court judge, Judge Yoon, who issued an injunction back in March when the administration fired 1,400 DOE employees. That was the first assault on the department. Well, we can't abolish the department without cabinet level approval because it is a cabinet position. So let's have an end run around congressional oversight. We'll just fire everybody. Now, Judge Yun issued an injunction staying the implementation of that order, but in July, the Supreme Court vacated Judge Young's injunction, reinstated said the firings can proceed while the subject matter of the case continued to be litigated. And this is part of the larger picture of our country now being effectively governed by executive orders. Federal district court judges in 20 cases have issued injunctions questioning, vacating, challenging the scope of presidential authority. In 19 of those 20 cases, the Supreme Court has vacated the injunctions, allowed the orders to stand while the cases continue to be litigated. And these orders have occurred on the so-called shadow docket. And the things that's really dangerous about the shadow docket, when you vacate an emergency order, there's no requirement for the Supreme Court to issue an opinion. So in 19 out of 20 cases, the administration has prevailed. The majority has not issued an opinion. There have been some vigorous dissents. So, for example, in the firing of the 1,400 Department of Education employees, which functionally dismantles the department, Judge Sotomayor issued a blistering dissent, but that's what it is. We get these really evocative, passionate dissents, but we're essentially being governed, or excuse me, we're not being governed, but the Supreme Court is essentially, I think, ruling itself out of existence because as these executive orders are being issued without congressional oversight or Congress exercising its constitutionally delegated and statutorily delegated rights of oversight, and the Supreme Court vacating orders having the audacity to question the scope of presidential authority, we are being ruled by executive order. And since President Trump has taken office, well over 200 executive orders have been issued in a staggeringly short amount of time, far exceeding the scope of the use of executive orders in any other administration. This is unprecedented. What's also, part of the landscape, which has eviscerated our concepts of checks and balances, separation of powers, is that Congress, which has the authority to determine whether an emergency exists, has taken a pass in exercising that authority, and that may well be, given the political reality, they've chosen to follow the lead of the president and the administration. And the Supreme Court is essentially, as I indicated, in 19 out of 20 cases, has vacated injunctions questioning the scope of authority. So the bottom line is, what happens to checks and balances and separation of powers? So this is very, very dangerous. This threatens the constitutional scheme. It obviously threatens the rule of law. So what's going on with the Department of Education, I think, is part of a much larger landscape, a word that I used earlier, that I think should concern all Americans. We could have a vigorous conversation or debate about whether or not we should abolish public education and move in the direction of charters and magnets. I, for one, I think that would be ill-advised. I think that would devastate the lives of countless numbers of children, and I think is something that many Americans may not even be aware of.
So Jay, in regards to the vision, the administration's vision, Secretary McMahon's vision is that the federal government should get out of education and allow that to be governed by the states and the school districts and parental choice. The currently school districts receive some, albeit a significant amount of money from the Department of Education. And I think Secretary McMahon has recently said during the shutdown that the fact that these schools are continuing to, function notwithstanding the shutdown shows that the Department of Education is no longer necessary. So what is your view as to what's wrong with that vision of, saying that we're not going to have a federal Department of Education, that we're going to leave this to the states and the school districts and the parents to
Well,
run?
with the lack of federal oversight, not only are Title I and Title III monies being denied or limited as regards public education, any oversight of alleged civil rights violations and issues that might be appealed, that parents might want to raise or appeal, are out the window. And this notion, I'm glad you raised this issue or revisited this issue of returning control to local communities. Look what's happened historically when local communities determine are totally in control of what students learn and what they're taught. Well, I use the phrase, let's go back to this is an invitation to whitewash history and go back to the Jim Crow era. Uh, Governor DeSantis in Florida, for one, in several years ago, in talking about pernicious DEI policies, went so far as to talk about the good old days of slavery. Now, in fairness, he didn't say the good old days of slavery, but he did say, and this was widely reported on. This is not attributable to me, that there were positive things about slavery. So, for example, people learned trades. They learned how to become blacksmiths. So I think it's disingenuous to talk about the primary goal of dismantling the federal agency and federal oversight as intended as a well-intended effort to return education to local communities, because we've seen historically what that means. And this goes back to why the 13th, 14th, and 15th Amendments were actually enacted. Part of American history is the fact that there was a thing called slavery. We had a civil war, uh, uh, and part of the vision of the founders was to create a Bill of Rights to redress and change and acknowledge evolving social reality and history. That's why slaves were freed. That's why the 14th Amendment was enacted. It was not enacted primarily to ensure that if my white child went to school and felt disturbed by something he heard being mentioned in class, that he could feel that his civil rights were being violated. I think that's perverse. And I think that's an invitation to ignore the reality of where we've come from and to return to the past. And there are parts of the past that are less than glorious. Everybody invokes the wonderful vision of the founding fathers. Well, the founding fathers were exclusively white men with property. The Constitution allowed for slavery to continue. The Constitution was a compromise. Adding the Bill of Rights was a compromise. Adding the Electoral College was a compromise. And these compromises were deemed necessary to preserve the Union, to preserve the country. Now we're in a world where we want to return, or some people think we should return to those inglorious days. They were glorious days, but they were they were really um, concerning parts of our history that we can't or should not ignore. Many commentators, many experts, many scholars have called slavery our original sin, and we've never really come to terms with that. So I don't think I'm hyperbolic when I say that inviting local control of education totally without any type of oversight or any type of regulation could lead us down, or may lead us down a very, very slippery slope, and return to that era. Because I think we have really still not come to terms with that legacy. The fact that you could be criticized today for talking about part of this history is ignoring the reality of who we are as a people. We are a people. We are Black. We are brown. We are we are Americans. We're, and this, and I think students in schools have a right to understand who we are as Americans, and they also have a right, I think, and part of this conversation implicates freedom of speech. Can we really suppress conversations about what happened in Tulsa in 1921? Shouldn't we talk about that? Shouldn't we be allowed to talk about why there was a civil rights movement? Why Rosa Parks chose to sit on a bus in Montgomery, knowing that she was going to be arrested because her rights as an African American woman were less than that of a white American. Uh, we should acknowledge the reality and engage in discourse. And what's happening now, I think, which is part of the larger conversation, is that if we stifle free speech, then reasonable people cannot reasonably disagree and engage in provocative conversations. Uh, how will we learn? How will we progress? Um, we're living, unfortunately, in a climate now that if you disagree with the orthodoxy, uh, you might be investigated. I mean, back, we had, part of this country's history during the Red Scare, the fear of communism, is we created a House on Un-American Activities. In the aftermath of Charlie Kirk's, tragic assassination, anytime anybody's assassinated, it's tragic. There have been calls in Congress now to investigate so-called left-wing organizations that promote terrorism. Are we going to go back to an era in which if you disagree or voice dissent, which to me is part of why I'm proud to be an American, that's part of democracy, that I'm going to be put on a watch list, that I'm going to be investigated by a new House on Un-American Activities? So I don't think I'm being overly dramatic by raising these kinds of issues, because I think these kinds of consequences are foreseeable whenever you talk about suppressing freedom of speech and the freedom to exchange ideas in favor of imposing an orthodoxy that everybody must adhere to at the risk of being canceled or castigated. That's dangerous. That's dangerous, and quite candidly, it's the definition to me of what's un-American. I don't want to be totally negative. One of the exciting things I've seen in the current landscape is, I mentioned the advisory letters that were sent to K-12 educators, I believe. So as part of this effort to dismantle public education, uh, advisory letters were sent to every state and every state school district, warning, not warning, requiring school districts to require certification letters within 10 days, attesting to the fact that they were ceasing to teach anything remotely related to diversity, equity, and inclusion. And if they didn't, they would lose federal funding, Title I and Title III. And I think Title III, by the way, is the source of most special education funding, and also be threatened with prosecution, as I indicated earlier, under the Civil Rights Act. To me, the good news is that 25 states, according to my research, my most recent research indicates that 25 states have refused to take the knee. They have not filed these certification letters asserting that either they will not or they are currently in compliance with federal regulation. That, I assume, will be the subject of ongoing litigation. And also, as we get coming back to the order to fire 1,400 federal employees, while that was the injunctive order issued by Judge Young was vacated in July of 2025, there's still litigation ongoing. Recently, Judge Young has also raised questions regarding the shuttering, the closing of the Boston Office of Civil Rights Office, uh, saying that again, uh, uh, other orders in other federal district courts and others, and the Supreme Court ruling in another jurisdiction doesn't necessarily implicate the case he is hearing. So there are federal district court judges who are continuing to hear these cases challenging the scope of presidential authority. How this will play out is very, very unclear. I think ultimately this will come down to the question of voting. Maybe the votes from November 4th are an indication that perhaps growing numbers of people are dissatisfied with some of the current policy. But one of the this may feel tangential or seem tangential, but I don't think it is. Part of the issue of executive orders that raise concerns include the sending troops into American cities, the militarization of American cities, and is this part of a larger game plan? Is the end game here to have military deployed during elections uh, in a way that will chill or deter or attempt to deter people from voting? I think my rhetorical answer to that is yes. And the administration does not have to invoke the Insurrection Act to get military on the streets, apparently. Uh, while these orders are being challenged, this is ongoing in this country right now. So this seems to me clearly designed to chill, to threaten, to intimidate. One of the things that was really, really exciting to me was watching the news coverage late Tuesday of voters still online in California to vote in support of Proposition 50 in California regarding efforts to address gerrymandering that has occurred in Texas, sort of the Democrats' counter to that. And a reporter questioned a gentleman who was on the line. He probably had another 45 minutes to an hour to wait until he voted. In spite of information already coming in that the results were clearly in favor of Proposition 50, the reporter on one of the news channels I was watching asked this father who was holding a child, "Why are you still online?" And he said, "Because why are you here?" And he said, "I'm voting for my freedom." And that really got me. So I think there are numbers of a growing number of people who are concerned about being ruled in this fashion. And again, we chill democracy if we don't listen to every voice. And I think the efforts to dismantle the Department of Education under the dubious rationale of returning local control are part of a general game plan to chill dissent and disagreement. That's un-American. That does not make America great. And quite candidly, that's exceedingly unpatriotic.
So, Jay, we haven't in this country always had a Department of Education. It used to be, as a separate Department of Education, used to be under HEW. What is the problem with chopping up the various parts of the department, say putting career and technical education into Department of Labor, putting OCR investigations into Department of Justice, so Department of Justice Education Division will do those. putting special education services into a different place, like say HHS. What problem do you see with, closing the department in that fashion by just having it governed separately in separate agencies, going back to what
Well,
it was before there was a Department of Education?
right. Well, I think the reasons to create the DOE, and I think it dates, I think the 1978 or so, uh, is to have more a more ratchet or more regulated, coherent process so that these functions are not fragmented and are accessible. Let's talk about OCR, something that I think you have lived experience with, right?
Mhm.
Um, and I used this phrase before, a right without a remedy. So let's say we move the function of oversight of discrimination complaints to the Department of Justice. How does a parent access that right? A parent in Alabama or a parent in Massachusetts or a parent in Texas. You pick the state, red, blue, purple, who feels that their child has been treated unfairly, their individual education plan is not being implemented, their 504 accommodation rights have not been validated or met. If they can't seek redress locally uh, within their local Office of Civil Rights, assuming they've exhausted administrative remedies within the school district, what are they supposed to do? Can a family really access uh, uh, or motivate the Department of Justice to litigate the case for them, or will do they have to bring action against the department? I mean, I don't even know how a family would have the resources, the access to legal assistance to navigate that incredibly complicated landscape. So again, it's a right without a remedy. It's like saying, okay, this is what we're going to do, and that's the reality. You have no recourse. So you may have a student who has special education rights, and we could ignore them. We could just say, okay, too bad. Uh, and fragmentation, I think, becomes like a three-card Monte game. I might have a right. How do I find what it is, and how do I negotiate this? I keep using this word or this phrase, navigate the landscape, but how can you do that? Only families who are fairly affluent with access to very specialized and skilled attorneys can address those issues. And that's not the reality of many Americans. And it's increasingly not the reality for many Americans as the income disparities in this country heighten. We have more poor people. uh, so that
So,
I think that's one of the reasons for some coherent, coordinated way to address these issues rather than to compartmentalize and isolate them in a way that you cannot really look at in a coherent fashion. And it's important that when you take one action in one entity, it doesn't its consequence or impact in another has an effect, and you've got to understand how those entities affect each other. And if they're not regulated in a way that you could look at it in a coordinated fashion, you have fragmentation and confusion, uh,
so
and also from a governmental point of view, incredible inefficiency.
So let's talk about something else you said about charter schools and magnet schools. I mean, if you have a vision that parents should have a choice and that they feel that the public schools are failing them, that they are
Hmm.
providing them with an education that will allow them to compete in the marketplace, and so they want to go to choose a charter school that is maybe
Right.
run by the district or a magnet school. I mean,
Hmm.
what's the problem with that?
Well, I think the issue of charter and magnets, uh, I think it's a provocative subject matter, and I think when charters were first envisioned, they were envisioned as a way to experiment, to innovate, to create best practices that perhaps can be then brought into public education writ large. I don't think that charters were envisioned as a way to replace public education per se. Um, I think charters were a way to, I'm using charters as an example, to complement, to augment public education. Now we're talking about total privatization of education, replacing an entire system with privatization. And I think there's some really downsides to that. And some of the downsides include ceding total control to private corporations who fund private schools, lack of any oversight about equity, uh, the danger of wholesale implementation of zero tolerance programs for students, meaning one offense and you're out. One of the issues regarding the efforts to dismantle public education, which are related to this conversation now regarding zero tolerance as an example, uh, whether or not school districts choose to have police in schools, for example, as opposed, or private law enforcement, if you're running a charter, a totally privatized charter, regard efforts or edicts of the current administration to repeal all Obama era positive climate school guidelines, which were implemented back in 2014, urging that was another famous advisory letter under the Eric Holder DOJ administration, um, promoting positive school climate. Let's let's be sensitive to the fact that black and brown students are being suspended at much higher rates than our white students for theoretically the similar behaviors. Now, this was back in an era when we were becoming growingly concerned in all contexts, including educators, about zero tolerance, which adversely affects certain populations uh, in much greater numbers. So let's go back to 1999, Columbine. All right, one of the more infamous tragic school shootings. In the aftermath of Columbine, we see a real surge of school policing, implementation of zero tolerance, uh, uh, disciplinary regimes regarding school conduct. Now, beginning in 2000, the first year that the Department of Education, and it's another reason to have a Department of Education, was gathering national data, the numbers of black and brown students who have been excluded from schools compromises 2/3 of the total number. Ditto for school arrests, and the numbers are even higher for youth with who have disability. So people who say that's, people who talk about, and then police start coming into schools in much, much greater numbers. Uh, by the way, as regards school police, which is maybe it's another issue. School police were never really in public schools in significant numbers until after the 1954 Brown versus Board of Education School Desegregation Act. Since then, they've been deployed primarily in large schools of color, which have never had a school shooting. By the way, as regards school violence, reported incidents of school violence peaked in 1994, 5 years before Columbine, and were declining significantly by the time of Columbine, which raises questions about the need for zero tolerance school requirements. And by the way, zero tolerance school requirements, which are not race neutral in their application, as well as the deployment of school police. So it's related, it's related to this larger conversation, because charters and uh, have much more discretion regarding their school disciplinary regimes. Again, oversight is needed of that as well. So the 2014 Dignity in School campaign, which led to the Obama Holder school advisories about really thinking about who is getting suspended, why they're getting suspended, are we being race neutral, have been totally repealed and called back, again, as part of this notion under the current administration that that's not race neutral, that somehow we're going to be prejudiced now against white children. And that's illogical, that's counterintuitive. It ignores the data, the research, the data which shows that the kids who get suspended in schools are 2/3 of them since 2000, when we started gathering data, are black and brown, which relates to this other issue, which I'm so glad you asked the question, Adele, because I totally forgot this. Another part of the efforts to attack public education is explicit guidance and orders not to gather data on these issues. Let's not gather federal data on on which kids are getting suspended and excluded. The only data we should look at is what families. Let's gather data about whether or not there's a nuclear family. I don't even understand that. But let's turn our eyes, or let's turn our back on the reality of what goes on the ground. So if we turn local control to school districts, whether it's publication or local charters, nobody's going to know anything about this. We're going to say, well, it's not our business. It's up to parents. It's up to local school districts. If they don't want to gather data, if they don't care about who gets pushed out of schools, who is arrested, who is suspended or excluded, that's not our business. That's up to the schools. If we gather data, we're somehow violating the 14th Amendment because we're being race conscious. Race conscious. Well, we have to be race conscious. It's the reality. It's part of the reality of American history. So my head is sort of spinning because you've asked some really provocative questions, and it provokes more reaction from me. But I'm really glad you sort of mine that field, because we should gather data to make sure that every student, white students, black students, brown students, students with disabilities, students who identify as being gay. Yes, I'm sorry, there are gay students. Students who identify as being trans. Yes, there are people who are trans. That we know who these students are, and we know about the intersections of identity, and we know about which students get involved in child protection. Are they black, brown? Do they have open juvenile justice cases? Have they been suspended or excluded from school? There's a need to know these things so that every one of our students can be treated fairly and equally, and have actually access and a fair shot at the American dream. And you don't have a shot at the American dream until you have access to public education. So if we don't know how our children are being treated, how are we going to protect our children? How are they going to have a fair chance if we totally defer totally to the private sector and say, let's get out of the business of education? I think the implications are quite dangerous. And I think, again, it's not hyperbolic to say this is an invitation to go back to the Jim Crow era, when local communities determined who should go to school and who should not. And I think we know the sad answer to that. Who should go to college and who should not? Who should get a high school degree and who should not? Who is eligible for jobs without access to? Look, I do a lot of work in my area on issues related to the school to prison pipeline as part of the larger cradle to prison pipeline construct. Sad reality is poor people tend to be much more involved in our systems of state intervention. Why? Duh. I mean, do I have to really connect the dots for that? Students who don't graduate high school are 5 to 8 times more likely to later enter youth and the youth justice and the criminal legal system. Youth who end up in child protection are much more likely to end up in the youth and criminal legal system. the lifespans between people living in certain communities in Chicago, in Roxbury, Massachusetts, where I ran my youth advocacy project, vis-a-vis uh, uh, affluent white suburbs, have 30-year lifespan differentials. Where you live matters. Where you go to school matters. Which schools have resources, which schools don't. You want to talk about going back historically into history? You probably know, right, Adele, that when in the aftermath of the Brown versus Board of Education order saying that segregation in public schools is per se unconstitutional, that rather than comply with school required desegregation orders, some schools just closed their public systems of education. White students could afford to go, the white parents could afford to send their students to schools. Some schools were sort of privatized, some state schools were privatized, but only white students were able to attend those attend those schools. So is this a history we want to go back to, where we deny access to education to people who can't afford it? That's another issue regarding public education. If you're talking about, and I think, totally abolishing public education, and I wrote an article talk which is entitled the plot against public education, the plot against America's schools, and that's what this is. It's a plot that's out in plain view. It's laid out in Project 2025, and I think the logic, the rationale, returning control of public education to local control totally without any oversight is really, really dangerous and imperils the right of access to education for all students, particularly our most vulnerable students. You talk about withholding Title III money, you talk about withholding special education dollars. Let's just abolish the Department of Special Ed. Let's forget the IDEA was ever enacted. This is a world that I don't want my students to go to school in. I want my children, I want my children to have a fair shot. Again, no matter who I am. So all these issues are interrelated.
So you've touched on, and actually you've been reading my mind as I've been going through and thinking of other questions for you, but we talked a lot about race and what happens to the kids that, and that's your lived experience. What happens to the kids who are excluded through zero tolerance and the impact that that has in the pipeline issue. What about the kids with disabilities that, if you have charter schools and as opposed to public education, what happens to those kids in
They're
your
totally
experience?
lost. They're more disadvantaged than anybody. So, I have a lot of experience in this area too, so part of my experience, I was a public defender for 20 years. I was a judge for 24, and many of the students that I saw in both these contexts were students with disabilities. After I retired as a judge, one of my gigs was to be the interim director of an organization in Massachusetts called the Massachusetts Advocates for Children. It's an organization that looks at the intersection of youth with disabilities and educational opportunity. That's part of Mac's portfolio. These students are particularly at sea, and many charters do not provide special education services, and that may not even be required to do so if we go to a total privatization. That is scary indeed. There's a really, really chilling study that was done a few years ago by the UCLA Civil Rights Project, which at the time was run by Dan Lowson. And the study is called Disabling Inequity. And it's a national view, which is quite chilling, of how youth with disabilities are treated across the country. They're suspended from public schools at much higher rates than are their white counterparts, than the students without disabilities. If you're Black and brown and have a disability, that's a perverse daily double because the rates are even higher, and they're arrested at much higher rates. And these are within systems of public education. Imagine what it would be like in terms of having these students in a world where there's less oversight, less scrutiny. I think those numbers, which are tragically high now, would even be exponentially higher in terms of being excluded or pushed out of school. So that's a really, really dangerous issue. And part of this is related to another issue, which is related to public education, which is related to the dangers of returning total control to the local community. And that is the very unfortunate 1973 Supreme Court decision in a case called San Antonio versus Rodriguez. San Antonio versus Rodriguez is, in my estimation, one of the worst. Well, I shouldn't say worse. Let me say one of the more consequential Supreme Court decisions, because that case allowed essentially the property tax to be a determining factor in school funding and school resources. So this implicates the issues of race and class. And this is one of the reasons why local schools are still local schools now have areas or have some communities are incredibly under-resourced in terms of public education dollars. Where you live matters. So now 2025, 71 years after Brown, our schools are more desegregated than they were at the time of Brown, and the issues of poor schools and the lack of resources they have are higher. By the way, in terms of school resegregation, the most segregated school districts are actually in the Northeast. New York City, where I come from, has the most segregated school system in America. And meanwhile, Southern schools are still fighting in some areas 1954 era school desegregation edicts. So these issues are all interrelated. Blowing up public education is an invitation to sacrifice whatever progress we've made in the post-Brown era and return to a pre-Brown era where separate was never equal in public education. And that's what will happen if we end or abolish federal oversight of public education and abolish public education, which I think Project 2025 envisions.
Well, that's a great segue to our conclusion. Thank you, Jay. This has been a very engaging and thought-provoking discussion, and perhaps we should talk about some of these individual aspects in separate chats. Your insights not only deepened our understanding of the state of education on the profession, but also reminded us of our ongoing commitment needed to advance civil rights and social justice in all of these areas. To everyone who joined us today, thank you for being a part of this important dialogue. The issues we explored are complex and challenging, but by coming together in spaces like this, we're taking meaningful steps towards progress. Remember, the work doesn't stop here. It continues with the actions in our communities, our workplaces, and within the ABA. I encourage you to stay engaged with the ABA Civil Rights and Social Justice section. Visit our website, explore upcoming events, and consider joining one of our committees to help shape the work we're doing. You can do so at ambar.org/CRSJ. Once again, thank you to Jay and the team behind the scenes, Allie, and of course, all of you for making time to be here. We look forward to seeing you at our next chair chat and continuing this vital work together.
Thank you, Adele, for the opportunity. And remember, to everybody, we have to fight for the right to reasonably disagree with each other. That's part of what education means. Thank you.